Greetings, my fellow Americans, and welcome to another episode of the Great Montana Conspiracy Podcast. Tonight, as you can tell, our setup is quite a bit different. I actually have a backdrop, I have a new camera, we're trying a little studio project here. We'll probably be tweaking this a bit over the next few episodes as we try to get it right. But this is hopefully the new format for the podcast from here on forward. Tonight's episode is going to be on a person rather than a subject, because this is actually the first time I've had enough material to really just dive into one person, and that subject is Judge Heidi Ulbricht of the Flathead District Court, formerly of the Kalispell Municipal Court. This woman has plagued my existence as one of the many corrupt people in this community, and of course, speaking out against her, she is the judge who presides over my cases. So obviously, I'm likely to inflame a few people by going directly to the person rather than to the subject. Now, before I begin, as always, please, if you like this video, please share it. Tell people about it. Get the information out there. The more people get informed, especially as we're dealing with an individual tonight, we find out how these corrupt individuals work. It's not just the system, it's an actual individual, committing these crimes, committing these actions, and hiding under the auspice of being an elected official and a judge in order to conduct this just flagrant behavior and misconduct. But also, if you happen to be seeing this on YouTube, please like and subscribe and just help show your support and watch our episodes. They come out twice a week. Okay. As I've explained previously, I've been applying for conditional release from supervision. Anybody who's been watching my podcasts or read my blogs for any extended period of time, or even read my book, U.S. Political Prisoner, since 2004, you're well aware of my situation. I sued the city of Kalispell. Kalispell abducted my stepdaughters, held them in isolation until the eldest could be threatened and terrorized, to say that I touched her one time inappropriately and threw me in prison for it. The number of violations, criminal violations that were done to get me to this point have just been staggering. I've reported them, I've spoken out about them, and yet continuously nothing is ever done about them. Heidi Ulbricht is just one cog in a larger scale, and the only reason why she's the subject tonight is because she issued an order denying my petition of release. Now, keep in mind, I have been under their thumb for 18 years on a 20-year sentence. 5 years in prison because I refused to confess to a crime I did not commit. And then 13 years on the street. Well, almost 13. On February 20th, or actually February 18th, it will be officially 18 years that I've been enduring this. And Heidi Ulbricht has been a willing, active participant in aiding in this debacle for years. It started in 2009 and has been perpetually, as she's gained more influence in the community and more upstanding positions in the community, she's been the one who's been given unilateral control of my cases, and she's the one who is just abusing her power to make sure I stay thwarted. She's the reason why a lawsuit that I filed in 2007 against Margie Frida for the property that she stole when I went to prison has never seen the light of day, has never seen a jury trial, has never had a jury trial set, because she refuses to set it, because she knows full well that if I go in front of a jury, there's no way that she can continue to protect Margie Frida from these issues. She can't. The business was entirely in my name with the Montana Secretary of State. There is no disputing that. You put that in front of a 12-person jury, there's no way they can say the business was not mine. All the records were in my name. She knows this. They don't want me to prevail. They'll protect Mara to the end of the days, and they give it that unilateral control, and Ulbricht's the one doing it. Now, personally, I believe it started as Ulbricht thinking she's, championing a poor woman who's been threatened and intimidated. She's seen enough of this. She knows. I often say that she's not a very bright lady, but I say she's not bright because she's not really that versed well enough in the law to understand it. Or at least she's certainly not demonstrated in front of me, that she can actually read the law and understand what the law actually says. She has misapplied the law in so many circumstances, situations in front of me, that at a certain point you have to say, I don't think she really knows what she's talking about. But regardless of her reasoning and her rationality, the truth of the matter is that she has been a major player in what is being done to me. She may not have been one of the beginning ones, but as the concept of chain conspiracy exists, it doesn't matter that whether she was part of the original plan or whether she's a later addition to continue and perpetuate the problem. She is part of the problem. Now, as I've explained before, I wasn't expecting this motion to be granted. Okay? I knew going in that they were not going to release me. What infuriates me, enrages me, and upsets me to my core is the lies they can use to perpetuate and continue to do what they're doing. Heidi Ulbricht denied my motion on January 5th, 2022. Her reasons for denial are grossly inflammatory and deliberately misrepresent the record. But it's the record, and it goes on the record, it's a public record, and I need to speak out against it. And I will be speaking out against it in a motion for rehearing and an appeal, and I'll continue to fight this because that's what I do. Because I can't let these actions taken against me go without comment or without explanation, or to counter the misinformation and propaganda they put out there about me. I will obviously be appealing. I'm going to try for a motion for rehearing first. I say try. I'm going to file a motion for rehearing first. Ulbricht will not grant it. She's never granted anything that remotely gives me any freedom or liberty. She just, for lack of a better expression, she has a hard-on for this issue. She will not let it go. She refuses to admit she's wrong. She refuses to admit that Mara is the actual offender. She's the one harassing. She's the one terrorizing. She's the one abusing. She refuses to acknowledge that. I have to be the target, and that's what Heidi Ulbricht has started from the beginning, and she will not abandon that position regardless of the evidence that's put in front of her. What makes this most noteworthy and worth an episode of the Great Montana Conspiracy podcast is the level of dedication that keeps going in the recirculated lies and propaganda. There's a deliberate bias, there's a deliberate prejudice. These are not just happenstance people who don't understand. They know what they're saying, they know they're lying, they know they're presenting false information, but it benefits them, and therefore they continue to do so. Before I go on, I want to explain a concept, because I'm going to be talking about it a bit during this video. It's called mens rea. It's actually a Latin term. It refers to the intentional knowledge of wrongdoing that constitutes part of a crime, as opposed to the action or the conduct of the crime itself. If I go out, I turn on my car, and my car blows up, and shrapnel kills 3 people on the sidewalk. Did I deliberately kill 3 people? Of course I didn't. I had no deliberate knowledge that turning on my car would cause my car to explode, would cause shrapnel to go out and kill 3 people standing in front of my car, or walking by on the sidewalk on my car. No way I could have known that. Mens rea suggests that even though something that may have been a culpable act, without an intent, without knowledge of the act, something that's not deliberate, is not a crime. There must be an element of intent. There must be a knowledged intent or purpose before it can be a crime. There's a case in California. Now, notably, Montana is remarkably silent on the subject of mens rea. In fact, back in 1979, they removed the insanity defense from the law book to put an implied mens rea in place to basically say that, okay, you can't claim insanity defense in the state of Montana anymore. You just have to prove whether you have a deliberate intention or not. Yeah, good luck on doing that when you're dealing with somebody who has hallucinations or can't perceive the difference between reality and their fantasy world, who their ability to define the world is tainted by an inability to understand the world. You can't get a mens rea there, but Montana decided that was the appropriate thing to do. Like one of 9 states in the country that have done that. It's just a completely inappropriate application of law, but Montana legislators decided back in 1979 to do that. But there's a case called People v. Hall, and it's in California, and it comes out of the California Appellate Court. In fact, it's the California Appellate First District, 2015. It reads, the requirement that for a criminal conviction, the prosecution proves some form of guilty intent, knowledge, or criminal negligence is of such long-standing and so fundamental to our criminal law that penal statutes will often be construed to contain such an element despite the failure to expressly to state it. So basic is this mens rea requirement that it is an invariable element of every crime unless excluded expressly or by necessary implication. We see no reason why probation conditions would need to articulate mens rea requirements expressly when criminal statutes need not. It's a standard interpretation, it's a fair interpretation, it's an honest interpretation of mens rea. There must be an intent. You can't walk down the street, slip on ice, knock someone down, have that person hit their head and die, and go to the electric chair. You had no deliberate intent to hurt that person. And yet, welcome to Montana, and welcome to what's being done to me all the time. In order for Ulbricht to do what she's done, she had to cite several actions against me from the past that, of course, have been accumulating as the courts have tried to revoke me and tried to modify my conditions to make it hard for me out here, to silence me, to make sure that I can't say things, that I can't do things, that limits my ability to freely speak to the world, to the community. But in order to do this, she had to expressly come along and rehash some of this stuff and make up new interpretations. And of course she has to take things out of context, because she can't take things in context. For instance, one of the things she cites in the order goes back to my first revocation attempt that she does not mention, incidentally. She does not mention that she cites that Dave Edwards, my first probation officer, petitioned the court and obtained modifications of my condition. She omits entirely that that was immediately following a failed revocation attempt, when Dave Edwards sat across the table from me, or across the desk from me, and told me I needed to stop trying to overturn my conviction through appeal, that I needed to stop trying to pursue the property that was stolen from me when I was arrested through court, that I needed to stop filing actions, and if I filed another legal action in court, I'd go back to jail. And I told Dave Edwards, I said, if you're accused of a heinous crime that's going to plague you for the rest of your life that you did not do, at what point are you going to stop fighting back? His response was, at the point it's going to send me back to prison, which is where you're going if you file one more action. Me, I went home and filed a habeas corpus. 2 days later, Edwards shows up at my place with a revocation and is trying to throw me into prison. I was out of prison for 2 months at that point. This happened around latter part of March, first part of April of 2009. Okay, keep this in mind. I had not been on the street long enough to do much of anything. I've been trying to go to voc rehab. Dave Edwards was trying to sabotage that and limit my ability to do that. I was applying for Social Security benefits. I found out later that he immediately ran to the Social Security office when he had me revoked and tried to tell them that I couldn't apply for benefits because I was in prison. I was going to prison. He ran to the voc rehab office and said I was no longer going to be eligible to participate in their program because I was going to prison. He did everything he could to sabotage and make it impossible, because one of his primary elements for going back, for trying to revoke me, was that I had no money or income, had no ability to pay for any of what he deemed court-ordered treatment. There was no court-ordered treatment. I had complied and completed all my treatment in prison. He wanted me to go through what was called Phase 2 of the Montana Sex Offenders Program, which has a mandatory, compulsory requirement that I confess. He wanted my confession. He wanted me to confess to a crime that I had maintained my innocence of since day one. Montana has Phase 1, Phase 2, Phase 3 sex offenders, and they have the tier level sex offender treatment. I went through the first phase, completed it, no problems, no recommendation to continue to the second phase, until I came out and Dave Edwards said, I'm not going to let you stay out if you don't take this course. I said, I'm not required to. I met all my court conditions. In spite of that, I was out there trying to find a way to meet this condition. I didn't want to go back to prison. But I didn't have any money because my Social Security application hadn't come through yet. Went to jail because it already is. If you had just sat back and done nothing, had not been so aggressive to try to shut down my methods of support. Social Security had sent me a letter that was asking me to sign and verify information for my application. They didn't know where I was because he had me arrested. He then went in violation of every standard of law and ransacked my apartment after I was in jail. Now, mind you, when on probation, I'm required to consent to warrantless searches, which means that if my probation officer comes to me and says, I want to search your house, I want to search your computer, I want to search your phone, I have to give him consent or it's a violation of my release conditions. But that consent element isn't vital. He can't just come into my house when I'm not home. He can't just go in my car, break into my car, grab my laptop and run off with it. I have to be able to consent or decline. Going into my home was a trespassing crime. The fact he ransacked my apartment, he was trying to find something to further justify the revocation. He couldn't find it because it didn't exist. But this was how over-the-top zealous this man was to try to send me away. By calling Social Security and telling them where I was, allowed them to send that letter to me. I was able to sign it, return it, and I got approved my Social Security benefits. I would not have been able to if he had just sat back and done nothing. But he was so overzealous that he couldn't sit back and try and not try to do everything in his power to make sure I had no support going into that revocation hearing. What happens? I walk in the revocation hearing and I say, I have support. I have Social Security as soon as I get out. All because he tried to sabotage it. Now keep in mind, he's also the one who's responsible for the first restraining order attempt for Mara to me. He knew I was out trying to locate Mara's address so I could have her served with the lawsuit, because while in jail I couldn't find her address. So I was out trying to track down her old addresses, trying to track down where I could have her served, not trying to contact her, not sending any messages to her, just trying to find the physical address so I could serve her with the lawsuit. Dave Edwards found out I was doing this because I went to one of Mara's old addresses. Her landlord was apparently still in contact with her and informed her that I was out looking for her current address. Dave Edwards was notified. Dave Edwards tells her, look, you need to fight. He's out there. He's out to get you. You need to file a restraining order. Obviously nothing of the case. I'm trying to pursue things through the legal court system. I always have. I continue to do so. Everything I've done is in proper legal, by the book. It doesn't matter. I'm not allowed to do things by the book. Everything has to be twisted. I actually appeared at that first TRO, overseen by Judge Ulbricht when she was a municipal court judge. I had to attend it by teleconference. Interesting little fact, I had a friend, Don, who was sitting in the courtroom that day, and overheard that before they even started the hearing, Mara had a one-on-one conversation with Judge Ulbricht, in which Mara says, oh, Your Honor, I really hope you'll grant this because I'm really scared. And Ulbricht says, don't worry, I'll make sure the restraining order stays in place. It's called an ex parte communication. She had not heard any evidence. The case had not been called. The case is not anything. It's just waiting for me to get connected. Nothing was supposed to be proceeding. She had a one-on-one communication in open court in which she offered pre-assurances, a predisposition that she was going to grant this restraining order. I tried to get my friend Don to speak up to make a statement, but he'd seen what was done to me. And in seeing what was done to me, he didn't want to make a statement. It actually caused a falling out between us. We stopped being friends because I said, you know what? Because he had sat for the entire time I'd known him. Oh, I wish there was something I could do. I wish I could help you in some way. Here was a way he could help. He could have overturned that TRO. He could have done everything because here was a predisposition by a prejudiced and biased judge who made a decision before the hearing was ever started with a party in an ex parte communication, and he would not testify to what he saw. So it broke our friendship apart. But this is the kind of thing that Judge Ulbricht does. She's not a good judge. She is a corrupt judge, and she is a biased judge. Her reputation is she's a man-hater. She hates any men, and when it comes to a man and a woman, she will 99% of the time decide on behalf of a woman because women are victims, men are evil, men are wicked, and she will just do everything in her power to make sure the woman prevails regardless of how overwhelming the evidence is against the woman. She will give an automatic bias and prejudice leaning towards women. Always has, always will. I just demonstrated that in my case repeatedly. But Mara has actually filed 4 TROs. And she's made sure that every single one of them has gone before Ulbricht. When Ulbricht left the municipal court and went into the district court, she made sure that she filed her next restraining order attempt in the district court to make sure it was in front of Ulbricht. In each of these hearings, each one, without fail, she has said she doesn't want to be served with a lawsuit. And that's why she's filed the restraining order. She actually said at her first hearing that she heard I was trying to locate her for service and she didn't want to be served, and so she felt she needed to file a restraining order. You don't get to file restraining orders to stop being served with a lawsuit. It's not how it works. Her entire reasoning for being fearful of me at the first hearing was because Dave Edwards had told her. Dave Edwards was subpoenaed for that hearing. He didn't accept or show up for the warrant or for the subpoena, and Ulbricht let it pass. Didn't hold him accountable at all. I wanted to be able to get him on the stand and ask him what he told Mara. Did you tell Mara this? Because Mara's saying you did. Mara can't testify. Everything Mara says is hearsay. I need Dave Edwards on the stand. Ulbricht wouldn't enforce it. Why? Because I was the one who was being charged. I was the one being accused, and she's not out to prove my innocence or that I'm a victim. She's to prove that Mara's a victim. That's her job, how she sees it. She doesn't see it as equal jurisprudence. She sees it as it's her job to defend the woman. That's what her position is. Always has been. Every single time Mara's appeared in court, whether it's through her own direct testimony or when I ask her directly, she has admitted that she's filing the restraining order because she's trying to stop the lawsuit, and that she deliberately wants to be revoked and returned to prison. These are her openly declared statements at every single appearance she's ever made in front of Judge Ulbricht. These are not justifications for a TRO. These are vindictive, vexatious actions, and they ignore completely. And every single time I go in there, every single time, maybe not the first time, but every other time after that, I point out, I say, Your Honor, if you had granted and put this case before a jury, if you had actually put this civil case that you will not set a trial date for, if you had set a trial date and put this, we would not be here today. The only reason Mara is here is she's trying to stop this lawsuit that you should have put on the trial calendar years ago. Now keep in mind, she wasn't the original person who stopped this lawsuit. The original person who stopped this lawsuit was Peg Allison, clerk of court. She didn't want the lawsuit to go through. She refused to issue summons for years. It sat from 2000, it was originally filed in 2007. It got transferred to Flathead County in 2008. From 2008 to like 2011, when Heidi Ulbricht took office, I'm thinking it's 2011, maybe not accurate on that, but I think it's 2011 when she took office, took the federal district judge position. Until that point in time, 2011 or 2012, Peg Allison, the clerk of court, refused to issue summons. Refused to issue summons. Can't prosecute, can't serve somebody if you don't have an accurate summons. If you don't have a summons issued by the court where the case is filed, and she absolutely refused. Ulbricht took over and reviewing cases that Catherine Curtis, on her way outgoing, had pending, sent a request for a status update, asked why the case had not proceeded. I explained, she probably didn't even connect my name to the original case she'd heard in the city court at that point in time. But I explained, this case is ready to proceed. The clerk of court will not issue summons. A few weeks later, I get a letter from Peg Allison that says, I have been instructed to issue these summons, and finally includes the summons. Mara avoided service for 6 months after that. I finally had the sheriff's department serve her successfully. She didn't file a response. I filed for summary judgment. Ulbricht blocked it. Ulbricht wouldn't allow it to happen. The summons, the proof of service of the summons kept vanishing from the court file. I blame Peg Allison for that one, but regardless, the proof of service, Ulbricht wouldn't allow it. Mara was given an extraneous 3 extra weeks to file a response. And then once that was done, Ulbricht's decision was, well, now there's a response on file, so it's not appropriate to have a summary judgment. Ladies and gentlemen, the motion for default judgment, not summary judgment. The motion for default judgment was in the courtroom for weeks, in the docket for weeks. She doesn't get to file a statement later. The language of the law is very specific. It says that if the party does not respond, the court clerk must issue a default. Not may or should, must issue a default. Ulbricht blocked it. Ulbricht has continued to block every effort. Every time I filed 2 motions to set the trial schedule, she's ignored them. Every time I've tried to file any motion to create an impetus to get the case heard and set to trial, she's ignored. I've gone in front of her and pleaded at these TROs, if you just set the trial date, we will not be here. Because the only reason she is here, and she openly admits it every single time, that she's there to stop the lawsuit. She's not filing a TRO because she's afraid of me. She's filing a TRO and she's making up stuff so that it will stop the lawsuit. Which is where the impetus of another issue that's brought up in this order actually comes in, which I'll bring up a little bit later. But at any rate, the original revocation attempt by Dave Edwards was in front of Catherine Curtis. Immediately following that revocation attempt, here comes Dave Edwards, and he wants me to, he can't revoke me because I'm following the rules. So he wants to add rules to my probation so it'll make him easier for to revoke me. Well, obviously, I know the law. You can't do that. There's a case called State v. Fields. If you want to look it up, it's State v. Martin Minnow Field. It's the 11 Pacific 3rd, 1203. It's a 2000 case. But it basically prohibits probation and parole from modifying a sentence. The judge is the only one who can issue sentence conditions. Only one who can issue them. The court is forbidden to give that power to the probation and parole department. The probation and parole department is forbidden from usurping that power. The power in setting a judgment is limited to the courts alone. The probation office cannot force me to adhere to new conditions. And one of the new conditions he wanted me to do, because at the time I was putting out my Montana Conspiracy blog, the Great Montana Conspiracy in its original incarnation, online at monspiracy.wordpress.com, and it's still out there. But it's like no matter what I say or do, yeah, it's just so frustrating sometimes. But here he is trying to force me to sign new conditions, accept new conditions that are just wholly horrific, including I can't go any place where there's a reasonable expectation children could potentially be present. Ladies and gentlemen, that's pretty much everywhere. There's literally anywhere a child could potentially be, except maybe an adult strip club, and I'm not allowed to go to them. So obviously that's off the ticket. I lived in a public community building at the time that had children who came to visit the people who lived there. They could be expected to be in the hall, which means under that interpretation, I can't go into the hallway. He was actually trying to ban me from emergency rooms. He actually went into court on this modification hearing, and my attorney says, so Mr. Edwards, my client goes into court with a compound fracture, can't even walk, or goes into the emergency room with a compound fracture, and he can't even put weight on his leg. And a child comes in, you expect him to leave? And Edwards says, I would expect him to remove himself from that situation. Ladies and gentlemen, have you heard anything even remotely as absurd as that? I am hypothetically in critical pain, unable to even bear weight on my leg. A child comes in and I have to walk away from medical treatment, much needed medical treatment. My leg could be hemorrhaging, I could lose my leg, I could lose my blood poisoning, sepsis could set in, any number of things could set in from a compound fracture. He's telling me I need to remove myself from that situation because he says so. Now, in all fairness, many of these conditions, some of these conditions were not granted. I was actually held under 8 months of those conditions because Curtis took her own sweet time in issuing a final order on the modifications. And it told me in the meantime I had to follow all instructions and directions from a probation officer. Again, violates State v. Field. Court cannot give the probation office the power to impose new conditions of my probation. And yet she did, because this is Montana, they ignore the law routinely, especially when it comes to me. But after 8 months, I literally had to live in my 1-bedroom room. I had to wait till evening when there was no chance that children could be awake to go to the bathroom. I had to send people to the grocery store to go shopping for me. The only time I was allowed out of my room was to go see my probation officer. That was it. for 8 months. That was my existence because of Dave Edwards. Vindictive, just horrifically zealous man who was trying his level best to revoke me in any way he could. And this is all the stuff that Heidi Ulbricht leaves out of this order. Leaves out what he was trying to do, how the circumstances came about, these modifications. But she brings up specifically the modification that bars me from speaking my alleged victim's name, because I'm mentioning it on my blog. Now keep in mind, at the time, when I got arrested in 2004, I was online pleading for help and assistance. Before there was ever a charge, before there was ever a crime, I had the city of Kalispell harassing me for months. They abducted my stepdaughters through illegal methods. Illegal methods. I cited 20 different laws they violated in taking the children. And all this was online, and their names, my alleged victim's name, was online. It already was out there. You didn't even have to try. It wasn't a matter. And then by the time, between 2004 and 2009 when I got out, that database, that web page had fallen into a database I had no control over. I couldn't modify it if I wanted to modify it because it was in a database. I didn't have any control over it. It was already out there. There wasn't anything I could do to stop it from being out there. So I didn't see a reason why I needed to not use her name because it was already out there, because I already been using it in 2004 before there was ever a charge, before there was ever a conviction, before there was ever a condition, or even a request. Now, of course, they like to taint it and say, oh, it was re-victimizing her and blah, blah, blah. Ladies and gentlemen, who's the victim? When you see all this stuff that's being done to me by this probation officer, this is just one fraction. You see all this stuff done by Ulbricht, that's just one fraction. I'm being victimized constantly. My name is being torn through the mud. Lies are being told about me on a regular and routine basis. I can't even date anybody because of the restrictions that are over me. Restrictions that nobody else in the state has. I have. Because I'm a political prisoner, I'm not a real criminal, and they know it. Everybody attached to this knows it. But they want me to shut up. They want me to shut up because if I shut up, they don't have to worry about me ever overturning my conviction, ever proving they're the actual criminals, ever having to answer for their own misconduct. Because they get to protect themselves in an elite level of government, and they don't have to answer for any of this. And that's why I'm at where I'm at. But when you go down in the situation and you see a probation officer that says you can't use her name, I'm sorry, but how do I not talk about her and not use her name? How do I protest my innocence and not use her name? How do I talk about the situation, the circumstances leading up to this, and not use her name? They take the idea that I'm sitting here and saying that she's lying, that she was threatened, she was intimidated, she was terrorized, she was taken out of her home and told she could never return home if she didn't do something. This is somehow degrading to her. That I'm somehow re-victimizing her. Because I'm insisting on the truth. She's insisting on a version of events that she's been told to say. And I don't have the right, under freedom of speech, to say this. I'm sorry, but I absolutely do. It's a U.S. constitutional right. I'm not calling her names. I'm not calling her, I use the term she lied, and of course they turn around and say, I'm calling her a liar. No, I said she lied. She lied does not the same thing as she's a liar. A liar is somebody who lies constantly. I said she lied because she was put under threats, under intimidation, and she was given promises and incentives to lie. And she did, and it was true. But my voice is not allowed to be spoken because it makes the officials look bad. So they've got to silence me. So Ulbricht makes this point of bringing up that, Dave Edwards has cited this and puts this big long quote from Dave Edwards into the order, alleging my insensitivity to my alleged victim. I'm telling my side of the story, ladies and gentlemen. I'm not calling her names. I'm not saying anything more than the fact that she was threatened and terrorized, and that she succumbed to this threats and terrorism to try to get a semblance of life back. I see this happen with people threatened with prosecutions all the time. Why is it so inconceivable that a child could have to endure it? Of course a child can endure it. They're more vulnerable than adults. can't say the government's doing this because that would be bad. The bottom line is that, yes, this condition existed and it was created because it was one of, what she leaves out is it was one of dozens of modifications he tried to enforce upon me, only a handful of which were adopted, and that was one of them. Ignores the fact that there's a good, 20 conditions out there that he wanted that he didn't get. So ignore the fact that he sought this massive overhaul of my supervision. Let's focus on this one area because it just happens to be that a few years later down the line, I published U.S. Political Prisoners since 2004. And I did my level best to go through. I had 3 other people, including, by the way, Angela Townsend, who will come up as a point later on in this podcast. Angela Townsend was given a copy and asked to go through and look to make sure I had not missed, because I scanned several official records. CPS records, police records, transcripts of interviews. I did everything I could consciously to strike. I submitted it to Angela Townsend. I found 2 other people online who solicited for editing books and content, had them review it. 3 people, including 4th people, including myself, missed, or I possibly believe that Angela Townsend, in hindsight, might actually have found it and kept it back as ammunition. Don't know that for sure, but considering the fact that Angela Townsend and Mara have collaborated in the past, it would not surprise me in the least. But regardless, Angela Townsend was one of the people who went through the book, or supposed to have gone through the book. I still have no evidence she actually went through the book. It was given to her. She was asked to. She said she did. She didn't exactly submit me, documents finding mistakes. She just said, I didn't find any. So, who knows? But regardless, I did everything in my level of power. I published the book with the sincere and genuine belief that I had struck every instance of her name from the book, from any of the official records scanned in the appendix of the book. Nowhere in my own free-form writing does her name appear. In fact, I refer to her as Daughter 1 throughout the book. One place in the appendix of a police report, surrounded by thousands of other blacked out redactions, her first name appeared once. Her first name. You can't identify somebody by their first name. Okay? Point of fact, you can't just go, okay, Fred did this. Okay, yeah, you've mentioned Fred's name. Obviously, that is not my alleged victim's name. I'm just saying Fred. You can't take the name Fred and say, okay, I can identify this person by their first name. There's no identifying. Okay? Even if it was a name like Timbacula, there's probably, you're not going to be able to find somebody with the name Timbacula in the country. Just by that first name, you have to have a first and a last name. This was not identifying. But it was enough that Mara went through my book, and I saw the book that she turned over to my probation officer at the time, Brock O'Hara. That thing had 100 sticky notes if it had one. All these different things that she was trying to say were violations, all these different things she was complaining about, all these different things that she was trying to get me revoked on. Now keep in mind, at this point in time, she'd already pursued, I think at that point, 3 different attempts at trying to have me revoked through a restraining order. Okay? And that had failed. So she tried to get my book and go through it and go through it and go through it and highlight all these different areas. And I was watching as he flipped through these books and he was trying to find the right place to talk to me about all these sticky notes and all these highlighted areas. I'm like, she took a 431-page book and she dissected it. She dissected it looking for anything she could use. And she had over 100 markings in that book trying to find something that she could use. She found one place, one thing. In the police report, I missed my alleged victim's name one time. A probation officer came to me, brought it to my attention, and said, I didn't know that was there. I can fix it, no problem. Or you can't? Yeah, no problem. He didn't even have to ask me to fix it. He just said, he brought it to my attention to go, I said, I wasn't aware it was there. I wasn't aware, it was not my intention. I can redact it, not a problem. Went in that day, pulled up an image of the PDF, blacked out the line, put it back in, rebundled it, uploaded the book to my print-on-demand company, Amazon. Which means every book sold after that point in time would have their correction. Problem solved. Mara wasn't happy with that. Mara kept pushing. Well, she finally got the county attorney involved. The county attorney filed for revocation against me. Revocation came back, or came down. Second revocation attempt. Now keep in mind, the county attorney's office is named, the head prosecutor is named in the book. Not only in the book, he's named on the cover of the book. Huge conflict of interest. His office should never have been able to handle the prosecution to begin with, much less under the circumstances. Because both Montana law and federal law have double jeopardy standards. You can't punish someone twice for the same offense. As far as the probation department was concerned, I had already been sanctioned for bringing my alleged victim's name into a print publication, and their condition, mind you, I wasn't told this at the time because this was all, I was so aggrieved myself that I had made this mistake that I volunteered to fix it right away. Before I was even told I had to fix it or else. I fixed it because it was never my intention to have her name in the book. It was never my intention. It was my intention to strike her name everywhere it appeared. I missed a spot. Easy fix, no problem. Well, it turns out what I wasn't aware of was they actually staffed this behind the scenes and made a decision from higher up above Brock that I was going to be given the choice to either fix it or be revoked. He didn't even have to get that far. He never even had to threaten me because once he told me about it and pointed it out to me, I'm like, oh, I didn't realize it was there. I can fix that, no problem. That's easy. Easy fix. He didn't have to get to the point where he said, you need to remove this or else, because I had not intended to have it in there and I knew I could fix it, and I did. But because it was staffed with the higher ups, it was even though the threat wasn't delivered to me, the threat was on the record, I had already been sanctioned. Now remember mens reas? I brought this up earlier. Mens reas is a deliberate intention to do something that's criminal. And in the case of the California appellate case I cited earlier, it applies even to probation issues. They have to demonstrate a deliberate intent. Did I intend to have her name in the book? No. In fact, everything suggests, because there's thousands of redactions, there's no indexed reference to that point in the book, there's no references to it anywhere outside the book in publications or in publicity or in interviews or anything else mentioning that slip up. There's absolutely nothing to indicate that I had any knowledge prior to being brought to my attention that I had missed that occurrence. Mens reas applies. This issue was brought before Ulbricht. Ulbricht ignored it. Ulbricht realized this was an issue. But she decided to sidestep it, deny the revocation on the grounds that I had already been sanctioned for the activity. That way she didn't have to decide whether the action was actually legitimate or not legitimate. The fact is I had been sanctioned, I had accepted the sanction, I had not objected to the sanction, therefore she could accept that the sanction had occurred, punishment had occurred, and therefore it could not be revoked upon the same principle. That was it. That was the only ruling. She didn't make any decision or determination whether it was a legitimate sanction or whether it was a deliberate act. Now mind you, she insists in this new order that her determination was that, but that's not what she said or did at the time. She dismissed it on the grounds that I had already been sanctioned, not whether the sanction was valid, justified, or whether mens reas was applicable. She didn't even discuss mens reas. She ignored it entirely, just as she ignores it here. But she has no problem implying that I deliberately violated that condition. There was no deliberate act. It was not a deliberate or purposeful violation. It was a mens reas. It is the I'm walking down the road, bump into somebody who slips on ice and breaks their neck. Not deliberate. This is the issue. I mean, you sit here and you have all these issues that come up, and she twists things and she manipulates things, and it's all about what she can get away with and how she can just exclude critical parts of the record to present the story she wants to present. Curtis, like Ulbricht, completely disregarded the right to free speech when she set this condition. Supreme Court upheld it, but they upheld it with a non-citable order, which means specifically that it was only applied to me. I mentioned non-citable opinions in a podcast before. You can look it up. I had an entire subject on it. This is an example. I've mentioned that almost every time an order comes down against me, it's a non-citable opinion. This is an example. Even the Supreme Court recognized that the restrictions on freedom of speech and liberty were so invasive they could not let it be a precedent. So they made it exclusive only to me. They made it a non-published, non-citable opinion. And yet, Ulbricht cites it in this order. She specifically cites the language of the Supreme Court after the order specifically forbids it. Ulbricht cites it as justification. This was a reasonable restriction. No, it was a non-citable opinion for a reason, because it wasn't reasonable. The Supreme Court knew it wasn't reasonable. And Mike McGrath was the one who passed down the order of the court. And Mike McGrath was my former prosecutor when my case was being appealed on behalf of the state of Montana. Conflict of interest, ladies and gentlemen. Conflict of interest abounds when it comes to me, because people who have a conflict of interest, who have no legitimate reason and have a vested interest in upholding convictions that they have participated in prosecuting, are allowed to make judgments. Mike McGrath made the order, and she cites Mike McGrath to uphold her standards, even though he has a conflict of interest, has never been involved or even touched the case. He should have recused himself. He should not have been allowed to be, and that's another individual probably need to do an entire podcast on, is Mike McGrath and his criminal history as a Supreme Court justice. But another issue for another time. So what she does here is she takes this information and she twists it and she manipulates it. And even though Mara's overzealous efforts only found one area to pursue, and which led to the second revocation attempt, Ulbricht presided over it, and Ulbricht was the one who decided that she couldn't justify it, she couldn't bring it up. But she avoided the mens rea issue for this very reason. So she could say that this was a violation, that I had violated. No, a violation cannot occur if there's no deliberate intent. Deliberate intent is a mandatory element of any crime, any violation, anything. When I say in my motion for conditional release that I have not violated any conditions, I have maintained and been law-abiding, it's absolutely a true statement, because I did not deliver. I was sanctioned for a violation. The violation was, first of all, I wasn't even aware I was being sanctioned, because I wasn't even being told. I was just, this needs to be, this is a mistake in the book. Okay, no problem, I can fix it. That wasn't my intention. I'll fix it, no problem. I wasn't even given a condition or a threat or anything. I was just told, this is what's going on. I said, I can fix it. He says, oh, really? I said, yeah, no problem. It's a PDF. I just go in there and black it out, no problem. Fixed it that day. Sent a copy of it to him for verification. I wasn't even aware at the time that it was considered a sanction, because there was no threat imposed against me. He never even got to that point. As soon as he told me what had happened, I agreed to fix it, because it was never my intention. I didn't know it was there. Mens rea, ladies and gentlemen, you cannot be held accountable for something you did without deliberate intent. Therefore, there is no violation. She never ruled on the issue of mens rea when she dealt with the original revocation attempt. Yet now she comes up and tries to make it sound like it's a deliberate attempt to violate, and that somehow makes me a threat to the community. She brings up these TROs, these restraining orders, ignoring the fact that she actually quotes Mara's twice, even though Mara's had 4. And she cites Angela Townsend. And remember I mentioned I was going to bring up Angela Townsend. Angela Townsend stole a trademark from me. She came to me and asked me to help me rebrand her book. I came up with a title, told her she could use it so long as she gave me credit. She decided she didn't want to share it with me and took it for herself. I filed a federal lawsuit for a trademark violation. She ran to the state court to file a TRO, with her primary purpose being to stop me from using the name so she could continue to promote it. Judge Robert Allison granted that and restricted me and barred me from ever using the name for myself. And the name, by the way, the restraining order is long since expired. The name is The Forlorn. I came up with the name The Forlorn. It's not Angela Townsend's creation. I created it. She can claim it all she wants. I have documents, I have log entries on my podcast, on my online blog. Trust me, I created the name. She knows I created the name. And she took advantage of my situation and circumstances. And the fact that she worked as a legal assistant in a law office. And so she went to a favorable court because her attorney knew the judge. And so she went there and got her protection to continue to plagiarize or to continue to steal my trademark and use it for her own. Which, by the way, ended up going before Christensen in the federal court, who also knew the attorney she worked for. So he's deceased now. There's no point bringing his name up. But okay, fine. McGarvey. Yeah. But anyway, it is what it is. The idea here, though, is that when she brings up these TROs, she doesn't bring up the fact that in every instance, they're retaliatory. It's because I have filed a legal action and they have filed an action to try to use a TRO to quash the action. In open court, Mara acknowledged it. In open court, Angela Townsend acknowledged that there was a federal court pending on this issue. State didn't have jurisdiction. Federal court had jurisdiction. State usurped jurisdiction. Gave it to her, banned me from speaking the name. These are the TROs. Angela Townsend actually was trying to build a case of trying to make these false claims to the police department. Trying to claim I was driving by her house and by her work. Once in a white truck, once in a red truck. I can't remember which one. Once a white truck, I think, was at her house, and I think she was saying the red truck was driving around her work. Regardless, I didn't even own a vehicle at the time. I didn't know anybody who had white trucks or red trucks. But when I was getting calls from the police department telling me that I needed to stop driving around and harassing her, I went down to the police station to make a report saying these are false reports. You need to hold her accountable. These are false reports. I've been home all night. As I'm sitting in the lobby, of the police department, and I've been there for like 15 minutes, she calls in and she says, I just saw him. He just drove by and he made an angry face. I'm sitting in the police department. Clearly I could not have just driven by her house. I was in the police department. I was sitting in the lobby of the police department. They knew exactly where I was. Later, when she filed this restraining order and she tried to bring it out, she filed it under her own name. I filed a rebuttal to the things she said and sent it to her address through the U.S. mail. She tried to go back to the police department and say I had violated the restraining order because I had sent it to her. No, because she had an attorney. There was no attorney listed in legal papers. The only service address was her home address. It's the only place I could file a legal response to, and I served it through the U.S. mail, not directly. I told the police officer what had happened. He laughed. He goes, yeah, I remember that. Everyone was laughing about it. It was a laughing story that had circulated the police department because they had known what she had done and they laughed about it. And yet, even the police officer said no violation. And clearly there's no violation. She tried to claim there was no violation. Everyone knows it. Because I was responding to a legal action. I have the right to respond to a legal action, and I did not go directly. I sent something to the U.S. mail through the proper format. There was no cover letter. There was no nothing. It was just a simple legal form I filed in the court. Even the police officer acknowledged that. There was no violation. And so nothing was ever reported. No crime, no complaint was ever drawn up. In spite of the fact that Ulbricht insists in this letter that these multiple restraining orders exist and that reasons of infractions exist in these, she's full of it. And she knows it. There's never been a violation of any of these TROs because there was never grounds for the TROs to begin with. There was never a violation. There was no restriction. You know, I'll scan this and make it available so that you guys can see the order for yourself. And you can see how inflammatory it is and how derogatory it is and how twisted it is. But she can't sit here and say that, and her actual language, and I'll pull it up here, her actual language in the order is that the defendant as well as the defendant has disregarded certain of these orders. What orders have I disregarded? Seriously, what orders have I disregarded? What restraining orders have I disregarded? She can't cite them. They don't exist. She knows it. She's just making this vague statement that I not only had people compelled to bring restraining orders against me, but I've also violated those restraining orders. No, I haven't. Show me one case where I violated a restraining order. Show me one case, one instance. Other than Angela Townsend calling and complaining and Mara making multiple claims of nonsense, no violation has ever been filed against me. There's no record of any violations because no violations ever occurred. So no, I mean, it's nonsense. Everything she says is nonsense. It's twisted, it's manipulated to get the advantage that somehow I'm this predatory, dangerous person out in the community when I'm not. Keep in mind, I have been under their thumb for 18 years. I've got 2 years left. I have every expectation in the next 2 years they're going to try to make an attempt. There's a reason why they don't want me let out. 18 years. There's been no claims against me, TROs or otherwise, in years. Okay? There's been no claims of any kind against me in years. They've had me under supervision for almost 13 years. They had me in prison for 5 years before that. There's no reasonable justification to keep me under supervision, to keep me in custody, other than the fact that they don't want to let me go because they want to keep these conditions over me. They don't, believe me, for all that I am saying, there's so much I'm not saying. And you have to understand that right from the get-go. There's a lot I am forbidden to say. There's a lot I cannot say. Not just my alleged victim's name. I'm not allowed to say certain things because every time I try to bring them up, I'm retaliated against. They try to revoke me. They try to bring up these nonsense complaints. They try to threaten me, intimidate me. They go to my friends. My friends get threatened and intimidated. It's this horrific, retaliatory, punitive system. If I speak out, there's certain things I cannot say. This is actually really borderline. This episode tonight is really borderline because I'm going after the judge who's presiding over me, who has absolute power and control over my life. So yeah, have every expectation. This is not good for me. It's really not good for me. But I can't remain silent. One of the things, I mean, they've tried twice to revoke me. They have failed both times. They're frivolous grounds. They're ridiculous grounds. They're trying and they're desperate. And I'm not out here. I'm not a criminal. I'm not doing drugs. I'm not out here prostituting people. I'm not out here breaking into people's houses, doing whatever. I'm a law-abiding citizen, ladies and gentlemen. I am more law-abiding than most people because there are rules that I'm held over that nobody else in the state has. I'm held to. I'm restricted in ways that nobody else can. I mean, it's just completely ridiculous, the things I'm being held to, required of. For the level of the allegation against me, and to have these people in the community, I mean, just a couple of weeks ago, when Mara found out about my attempt to get released, she called up, in my probation officer's words, in a tizzy, and tried to claim I was stalking her dad's house. I mean, she knows she has security cameras. I'm best friends with her neighbor. I've been friends with her neighbor, Jean Fox, since 2001 or so. I mean, we met each other online. We did a whole bunch of stuff when we never actually met her in person until I got out of prison, but we were friends online. We've known each other for years. I can't go to her house because she's neighbors with Mara. If I go to Jean's house, Mara calls the police and claims I'm there to harass her, even though there's absolutely no connection whatsoever. It's all harassment, it's all provocation. Anybody who can see, she has security cameras out there. And she keeps pulling these security cameras trying to claim I'm their harasser because she can see me pulling my car. I parked my car 2 trailers away. You can see on the video where, I mean, and there's another situation that happened. I wanted to prove that I had never been on her property. I'd never even tried to talk to her. And I wanted her to prove, she had this big, long, elaborate story about how the one time she saw me out at my friend's house, as she became terrified, had an asthma attack, and had to go back in the house and recover for several hours, and she lost weight just for work. Only I knew what had happened. The one time I saw her, she saw me, glared, got inside the passenger side of the car, and drove off. And I wanted that on the video. I wanted the record of it. I knew she had a video camera. I subpoenaed it. She fought it. Ulbricht told her she had to prove it. That clip was redacted, cut out of the video. It was so obvious. All it showed was the cars pulling out. Not who was in the cars, not anything. Her walking up to the car, her reaction to seeing me, none of that on the video. All gone. I brought it up to Ulbricht. She needs to be held in contempt. She's clearly doctored these records. She's clearly excluded evidence that would prove she's lying, and Ulbricht still granted the restraining order and didn't do a dang thing to her. This is who Ulbricht is, ladies and gentlemen. This is your judge. This is the person who is presiding over your cases who you're trying and hoping is going to be fair. She's not fair. She's not lawful. She's not true. She's not an upstanding citizen. She is a criminal operating under the pretense of law. And she has all this power because you give it to her through your electoral process. And that's what we have. We have a corrupt judge. We have 4 corrupt judges. This is just one of them. And it's the one who's always twisted the versions of the truth to benefit whatever agenda she has. I mentioned during the second revocation, Mara's alleged reasons, in this order she cites an issue, once again, that she deliberately misinterpreted, she deliberately misquoted, took out of context. During the course of the second revocation, on my blog, I was saying, look, Mara is claiming the reason why she's pursuing this revocation, she's trying to protect her daughter. She's protecting her daughter because I mentioned her name supposedly, deliberately, with malicious intent or whatever. It was from a police report. It wasn't even my words. It was a police report. But hey. And I put it out on my blog. I said, and you can look it up. It's on my blog. I said, this makes absolutely no sense. She's claiming she's doing this to protect her daughter, yet the condition she's complaining about is specifically a probation condition. If she revokes me and sends me back to prison, that probation condition goes away. There's nothing stopping me saying her name anymore. And just because I'm out in the public, I have a third-party person who years ago, when my first revocation was attempted, I gave copies of all my legal papers to. I said, there's nothing stopping him from dumping this information on the internet and making it public if he loses contact with me. There's nothing at all that says that it's proper or legal. I mean, nothing she's doing is going to prevent me from doing it. In fact, what she's doing is encouraging me to do it because I will no longer have that limitation over my head. And I said, well, that's not what she's doing. What she's doing is trying to revoke me so I can't pursue the lawsuit against her, as she has quoted and testified to numerous times in court. And this is what we have. We have a situation to where you don't have any fairness or justice. And I'm running out of power on this battery, so I'm going to have to end this tonight. This is a new process. We'll get to it. But I'll try to add to this. But it looks like I am at very low percentage. We'll see how much further I can go before I have to stop. But when this whole issue came up with me supposedly saying this and threatening, of course, Ulbricht twisted around and said I was threatening to release her information. No, I put it out there as a positive, logical argument. If she's so concerned about this, why is she trying to remove the condition that she's complaining about? Because if I go back to prison, that's exactly what happens. My friend issued a statement in response to this. And he said, and he did it anonymously, put it in an anonymous handle. He said, I'm the one who was given the records Mr. Edwards at the time was harassing Ron, and he threatened both mine and his safety security by illegally searching my laptop and threatening to arrest us both if I did not consent to a search of my laptop. These records and only other copies I have are securely stored and locked in a location only accessible by myself. They were given to me in the event something happened to Ron. I am not going to release any information or records I do have to anybody without due cause. No personally identifiable information other than names is within the information. Mr. Edwards, when he did as he did, was threatening Ron in more than one way with security and safety. I was present when Mr. Edwards attempted to steal Ron's laptop for a second time, and he threatened to steal mine. He had no warrant as mentioned above. He even tried to steal my other laptop, which was apart, and I've been working on to allow use for Ron's organization Game Hearts. It is my personal professional opinion that Mr. Edwards is and was a power-hungry, diabolical monster who sought to destroy people's lives instead of help them recover. This never-ending witch hunt against Mr. Ron Glick needs to stop. I was not given any instructions by Mr. Ron Glick to release any of this information and was given permission should something happen. This permission exists until from 2010 and is in regards to the above statement about losing contact. The Guardian Wolf, Maverick. Ulbricht is fully aware of this. She's fully aware of both my original statement. She's aware that Maverick has issued a statement contradicting it. But she has no problem pitching this false narrative that I threatened to release my alleged victim's name and information to the internet. I didn't threaten. I said, if Mara is so concerned with what's going on, why is she trying to penalize me and put me in prison, which would remove the very conditions she's complaining about? That's not a threat. That's saying this is illogical. This does not make any logical sense. This is not the true reason behind what she's doing. And here's the real reason. Ulbricht knows this, but she has no problem twisting the information. This is not, without a doubt, a flagrant attempt at defaming and justifying my continued detention. Because so long as I remain detained, they can do whatever they want to do. In spite of this aggressively permitting vexatious actions against me, multiple restraining orders, multiple attempts at revocation, she still, to this day, has not set a trial date for the civil case. She hasn't set a trial date. It's been pending since 2007. There's no trial date. I've reminded her multiple times, face-to-face, in person, in court appearances, in documents, to set a trial date. She won't, because she knows if it goes in front of a jury, I will win, Mara will lose, and everything that she's been trying to protect Mara from will come crashing down. So what do you do? What do you do when you have a judge that's so hell-bent on ruling against you? You know that no matter what you do is going to prevail. I've tried to have her recused 3 different times. Mike McGrath refuses to have, once again, Mike McGrath refuses to recuse her, allow me to recuse her for cause. Refuses to allow substitution. Refuses, I've tried to get cases out of this jurisdiction. The courts won't allow it. I'm stuck. I'm trapped in a jurisdiction I have no voice over. I've tried to take it to federal court. The federal court defends the state. So what do? Once again, one of my most famous quotes I really love, and I actually have the case that it comes from tonight. If something looks like a duck, walks like a duck, quacks like a duck, it must be a duck, even if it is holding a piece of paper saying it's a chicken. The case comes from Broadwater Development LLC versus Nelson, 2009, Montana 317. It is it's paragraph 5, by the way. It is a Montana decision that says that, and it's routinely ignored. Routinely. The bottom line is that everything Ulbricht cites has been from people with vested interests in keeping me detained, without a single reference to actual offenses raised or any counterpoints. These are all the aggressive, the most maligned, malignant ways she can misrepresent information she possibly can to make me look like I am a perpetual danger to society. And she knows I'm not. She knows it's her agenda. It's propaganda. Look back at my podcasts on propaganda. In Nazi Germany, citizens who aided the corrupt government were known as collaborators. People who gained special protection or privileges for doing the dirty work of the Nazi Party. I have dubbed it allowable misconduct. Allowance to steal, offend, commit whatever crime so long as the victim isn't undesirable, like myself. So long as people like Angela Townsend, they can steal trademarks, they can steal property, they can harass, threaten, make up false statements, but so long as I'm the one they're doing it against, they'll never face a day in fear. Never. In this case, there's no other way to look at this other than this is a very biased judge and prejudiced with a very specific agenda because nothing in her order reflects the truth. And she knows it doesn't reflect the truth. When I say she's not that smart, I say she's not smart in knowing the law. It doesn't mean she doesn't have a memory, and she doesn't know right from wrong, and she doesn't know truth from falsehood. She knows the truth. She won't speak it because it doesn't benefit her. She's not going to get protected by the Good Old Boy Network if she frees or takes the side of the person who's been attacking the Good Old Boy Network since 2003. I will obviously keep fighting. I will keep doing this until I have nothing else I can do. Until I'm dead in the ground, I'm going to maintain my innocence. I'll be filing for rehearing, and I'll of course try to set the record straight before it goes before the state Supreme Court, and I will appeal that after. That's all I can do. As always, if you're listening to this tonight, please like and subscribe. If you're watching it on YouTube, please, if you want to help us continue this project, help us with more improvements, more ways to get this information out there, by all means, look at the information attached to the video about how you can contribute to our cause. Also, keep in mind that if you're watching this video and you're not getting the original attachment or the information on how to contact my producer or myself, visit monspiracy.podbean.com and you can get the information there. And as I always say at the end of these videos, please, whenever possible, please be safe and please be free. Thank you.